asked loads of questions about the new Worker Protection Act, how that applies, whether existing whistleblowing setup will be sufficient, what else people should be thinking about. And we did a webinar a few weeks ago where we talked specifically around sort of our, I guess, interpretation of the Act, and also what, how you might apply your current whistleblowing practices to this. But very kindly, Robert and Sufia from Addleshaw Goddard, who will introduce themselves in a moment, are going to take us through, because I talked at the time that we're not legal experts, and we're very fortunate to have partners who are legal experts. So they're going to talk us through some of those legal aspects that, and we had some questions from the last webinar, which we will be addressing today. We've also got quite a few new people who've signed up to this webinar, so we are going to take you through some of the high-level principles as a reminder, or for anyone who hasn't seen it before, just to let them know the key principles of the new Act. So I'm going to be quiet now and pass over to Robert and Sufia to introduce themselves before we get into it.
Good afternoon, everyone, and it's lovely to be able to present to you today. I'm a legal director in Addleshaw Goddard's employment team, and I have a particular specialism in contentious employment law, looking at whistleblowing cases in particular. I'll hand over to Sufia for a quick intro.
Thanks, Robert, and thanks, Joanna. Great to be speaking today. I am an associate in the Global Investigations Department, and I specialise in safety, public inquests and inquiries, and risk assessments are part and parcel of what we do, and we'll cover that later, but that's what I'll be covering off today.
Well, without further ado, I will move to the next slide. And Robert and Sufia, if you just tell me when you want me to move slides, and I will do so.
Thank you. So I thought it would be helpful just to kick off with what is meant by sexual harassment, and a little bit of scene setting. This has been a hot topic for years, and if you can just see the reference to the Equality Act 2010 there is that's the definition that has been in place for that period of time, but there has been an increasing number of claims and a real number of high-profile cases. So clearly a lot of dangers in getting this wrong. So that's the law so far. But if you want to move to the next slide, we'll show you what is changing. And this is a new duty to prevent sexual harassment in the workplace. It came into effect on the 26th of October 2024 and was brought in by a piece of legislation introduced by the former Tory government, the Worker Protection Amendment of Equality Act 2010 Act 2023, a bit of a mouthful. But under that act, employers will be under a new duty to take reasonable steps to prevent sexual harassment of their employees in the course of their employment. What we have here is it's an anticipatory duty. So you've got to do things to anticipate and prevent this from happening. This duty can be enforced by the Equality and Human Rights Commission under its existing enforcement powers, but there's also enforcement in the Employment Tribunal. So they've removed all reasonable steps, but that's now been introduced again into the Employment Rights Bill by the Labour government, and there are amendments coming in. So this law isn't static, it's going to change again. And the new duty extends only to sexual harassment and not other forms of harassment based on other protected characteristics. But you've got the definition of sexual harassment on the previous slide. Another thing that's about to change is the third-party harassment. It was removed from the reintroduction of employer liability for harassment of employees by third parties, but that's only for the time being. It's going to be reintroduced in the Employment Rights Bill, and when that comes into force, we'll be dealing with updates on that. So the consequences, as I mentioned, enforcement by the Equality and Human Rights Commission using its existing enforcement powers, but probably the more likely form of penalty is a 25% uplift in compensation where an employer is in breach of duty. And there's a nuance with that. There's a question mark over what amount of compensation can be uplifted by up to 25%. And the explanatory notes to the bill say one thing and the legislation says something else. So that will have to be resolved by case law or perhaps also by the Employment Rights Bill. So if we move on to the next slide, please.
Trying to. There we go.
Brilliant, thank you. So when is there a breach of this duty? Looking at this in a bit more detail, that we've got step one: successful claims for sexual harassment. That is the key thing, and there can only be a breach of the new duty in the event of an employment tribunal upholding a claim for sexual harassment. And we've mentioned the consequences with the potential uplift of up to 25%. And you can see on this slide in square brackets the reference to compensation awarded for sexual harassment. The bit in square brackets is not certain, and there'll be a need for case law to resolve that. And I've touched on the enforcement piece there. The duty to prevent sexual harassment, as I said, it's an anticipatory duty, and there's a range of resources available, which are on the next slide. So these have been recently published and are publicly available, so you'll be able to get access to these resources, and they're a very helpful list of resources. You've got the Employment and Human Rights Commission updated technical guidance. You've got an 8-step guide for employers, which is a useful document. The checklist, again, by the EHRC, and an action plan together with a monitoring log that you can use. And ACAS has updated its guidance on sexual harassment. So what this is designed to make clear is the duty to prevent sexual harassment is an anticipatory duty designed to transform workplace cultures by requiring employers to take positive and proactive but reasonable steps to prevent sexual harassment of their workers. So employers shouldn't be waiting until a complaint of sexual harassment lands before they take action. The duty really requires employers to anticipate the scenarios when its workers may be subject to sexual harassment in the course of their employment, and to take action to prevent it from happening in the first place. And you can get that from the EHRC technical guidance.
Great guidance there, and I'm sure. Oh, sorry to interrupt. Go on.
Go ahead, please, Joanna. Yeah.
No, I was just saying, I think that there'll be some really interesting information there for our clients on the line, and I'm sure there may be some questions, although currently I can't see my chat, so I'll have a look at that at the end. But I do have a question from the last session that we did that I thought would be pertinent to ask you now, which is, does the Act extend to events where people are not at work as such, or maybe like off-site or unpaid voluntary events?
Yes, so that's a really good question. The definition makes clear that it's in the course of employment. That's quite a wide phrase, and there's no guidance currently on what is meant by in the course of employment in this particular context. But what we think is going to be applied is how you'd apply this phrase in the context of vicarious liability. And in that seam of case law sets out a very broad variety of acts that are treated as being done in the course of employment. So if it was a non-work event immediately after work, like people repairing to the local pub for a pint after work, that probably would be in the course of employment. And we as employment lawyers have a whole raft of cases that we can draw on that would be in the course of employment for that context. So it is much broader. There are some sort of crosshairs, if you will, on the Christmas party type event. So that's more obviously a work event if it's an event that the employer is going to be inviting the workforce to. But people who go on work-based trips, stay overnight in hotels, and are engaging with colleagues in the evening, that's likely, I think, to be in the course of employment. And it's part of one of the scenarios that I think Sufia will pick up on in some of the risk assessments that we come to look at, and the approach to that.
Thank you, that's great. So the next thing we're going to talk about is that Labour have introduced the Employment Rights Bill. That's going to be a lot of people are very interested in that at the moment. And there's specifically information there about sexual harassment and also around, I guess, whistleblowing as well. So just interested, and I will move on to the next slide, in how it would apply in this context.
Yes, three things I think to note about the Employment Rights Bill that are really relevant here. And when this bill comes into effect, it will substantially change the law. The first is the preventative duty on sexual harassment. It's going to be a duty to take all reasonable steps. So that will really expand that duty. Future regulations will be able to specify what steps are reasonable and the matters that businesses have regard to. But this act probably isn't going to come into force until I'm guessing here October 2026. So this isn't going to be imminent, but there's going to be a lot more people talking about these various issues. The second thing to be aware of is whistleblowing protection. Allegations of sexual harassment are going to be protected disclosures as a matter of law. So all the other forms of malpractice, wrongdoing will have a new body, and it will be allegations of sexual harassment as part of the Act. The reality is that is probably going to be, probably was covered by the Act already. A breach of a legal obligation would likely have covered that. But by bringing it into the Act, the Labour government is trying to emphasise that this is something they're taking seriously. And the third element is third-party harassment, employer liability for third-party harassment in relation to all relevant protected characteristics. So we're seeing these three changes being moved forward in the Employment Rights Bill that's currently working its way through Parliament.
Thank you.
So what amounts to a reasonable step? And looking at the various guidance, we've tried to distill it into these four stages of consideration. The first level is to consider the risks of sexual harassment occurring in all of these scenarios. And then number two, consider the steps that could be taken to reduce those risks and to prevent sexual harassment of workers. And once you've got to that stage, you'll consider which steps it would be reasonable to take. And that naturally infers that there'll be some steps that are unreasonable or not possible to take. And so you'll be casting the net wide to think what steps can be taken, and then labeling them as reasonable or unreasonable. And then you need to take action to implement all of the reasonable steps that have been identified in those documents. But that might lead a little bit into some of the topics that Sufia is going to cover shortly. So if we move on to the next slide, we've set out here 7 practical steps that are potentially reasonable and we think people will need to look through, and this is taken from some of the technical guidance that has been published. So these are things that we know that the EHRC will be looking to see in organizations. So they'll want to see a timetable for refresher training. So doing the training, having a training program in place, and ensuring that there's refresher training to raise awareness of rights related to sexual harassment. 3, a process for reviewing the effectiveness of updated policies and the effectiveness of the training. So that's this audit piece. Step 4, updating policies and procedures to bring clarity to the law, expected behaviours, complaints, mechanisms, things like that. 5, specific training for managers to support them dealing with complaints. 6, adopting a zero tolerance approach to third-party sexual harassment, and 7, informing third parties of the zero tolerance policy that you have in place. So if you're not doing these things, these are the key things that are likely to be on the radar or the checklist of regulators in this area.
A really useful slide for people to work through, and I'm sure we'll have lots of questions on, well, what does that all mean and what might that look like? But one of the questions we had last time was, we already have a dignity at work policy covering sexual harassment. Should we update this or create a separate policy? And I think there's quite a lot of questions around policies and, you know, what can be reused, what new stuff do we need?
Yeah, I don't think there's a legal requirement to have a separate policy, but what we're seeing in practice is that our clients are asking for a separate sexual harassment policy to really drill into these issues, because you have new duties and new responsibilities. And so our recommendation, although it's maybe not a legal requirement to have a separate one, is to deal with it separately. But each organisation can take their own choice. They can beef up their existing dignity at work policies, or you can have and that can cover more general things, or you can have a more bespoke, tailored policy to deal with the sexual harassment, and in particular the duty to prevent sexual harassment.
Thanks, Robert. The next question I've got, I'm not sure if it will be for yourself or Sufia, but we had a lot of questions last time around risk assessment, so it's great that we've got a section to cover that. So the questions that I have here are, who should conduct the risk assessment, and will we have one risk assessment covering the whole organisation with separate areas? So on to risk assessments, I guess.
So yeah, I'm happy to pick that one up. In terms of who should carry out risk assessments are already an established requirement under existing safety legislation and have to be carried out by what's referred to as a competent person. This is essentially someone in the business that has skills, knowledge and experience to conduct risk assessments, as well as a good understanding of the hazards or tasks being assessed. So in terms of risk assessment, specifically looking into sexual harassment, we've suggested that a joint approach is taken between those within HR departments that will be familiar with the company's policies and procedures around addressing sexual harassment in the workplace, preventing it, and those within the safety team that will already have that requisite knowledge of how businesses already approach assessing risks and combating risks, and the processes they have in place in relation to safety risk assessments that are already required. And we've seen clients take this approach in assessing risks arising from matters such as stress at work or mental health. And it's been a really effective way of making sure that risk assessments are suitable and sufficient, because it really, for topics like this, it really requires expertise on both sides. So that covers who should carry out the risk assessments. And in terms of whether one risk assessment is required covering the whole of an organisation, or whether multiple risk assessments are required, the legislation isn't really prescriptive on that. So it's a point that is left to the discretion of employers. It really depends on the nature of the business. So whether there's a single risk assessment covering all risks faced by all employees, or whether there's a suite of risk assessments, should be decided on the nature of risks faced by employees. So if we take an office-based business, for example, such as a consultancy or even a law firm, employees will face far fewer risks that compared to a business within the construction industry or employees working on construction sites. So the number of risk assessments required will naturally be fewer in that office-based environment as opposed to that construction site. And so really it's just a matter of discretion and what applies to that business. So it can be bespoke and tailored to each individual employers and employees' requirements in that sense. If we go on to the next slide, I've also set out some useful guidance and information about how to conduct risk assessments, because I appreciate if you're not used to conducting them, you might not really know how to approach it. The UK's workplace health and safety regulator, the Health and Safety Executive, recommends that an approach of plan, do, check and act is taken. And I won't go into a huge amount of detail in relation to each of these 4 steps. There is guidance available online, really easily accessible, really easy to read from the HSE as to what to do in relation to each of these steps. But just as an overview as to what is important in all 4 of these steps, really key for risk assessments is number 1, identifying the hazards. Identifying risk levels to be associated with those hazards, usually it's medium, high, low, and then identifying corrective actions that can be taken to eliminate the hazard, or if that's not possible, to at least control the risk of that hazard or reduce it to its least possible point. In terms of the next phase that is really important, it's implementation. It's all well and good having a piece of paper in place, having a policy in place. But the next phase is making sure those control measures are really implemented in practice and ensuring that those responsible for implementing those control measures that have been identified are aware of their responsibilities in relation to that, and are aware of timeframes potentially within which those control measures need to be implemented. So implementation is another key thing to take away. Performance also needs to be monitored, and that's where check comes in. There is again, nothing prescriptive, but guidance states that sexual harassment risk assessments should be carried out regularly. Within safety law, it's recommended that workplace risk assessments are reviewed annually. Because businesses already have to meet that requirement into safety law, it should be really easy to just include sexual harassment risk assessments within that existing process and review them annually, just to make sure that that duty is met. And finally, we have mitigating risks and acting. This is really about reviewing performance and making sure that any lessons learned are focused on, and that that key, I would say, key policies and procedures are updated to reflect those lessons learned. That policies are also handed out to third parties, and third parties that employers are working with are aware of those policies and procedures, and things like including expectations on behaviour and contractual terms can be a way of doing that, to make sure that third parties are also aware of their duties in relation to sexual harassment. And then providing training to staff is a key one. Just refreshers training, making sure that everyone is continuously aware of what the requirements are, and what the control measures are, and what employees and employers should be following. In terms of the common risk factors, we've included a few on screen. Those are just examples. So job insecurity, for example, would be workers on 0 hours contracts or agency staff. Power imbalances relates to those between senior and junior roles. Lone working and night working, that is particularly within customer facing roles, we would say. The presence of alcohol, so in pubs, bars, restaurants and other social settings, but of course also in work events, as Robert has mentioned previously. And then also workers being placed on secondment or attending events outside the usual working environment. It's not just within that workplace. It's when employees are going out to different environments but are still under their employer's obligation in terms of safety. So that is another thing to take into consideration. But I would say that these are just an example of common risk factors. Risk factors will differ from industry to industry. So again, it's all about looking at creating a bespoke risk assessment that applies to your organisation. And there is various guidance online that can assist with that, and also various different people that can advise. So we are used to advising clients on different kind of risk factors that they need to consider. So if you are unsure about what to include, it is worth consulting others. And I'm conscious on time, so the last thing I will say is that this duty is set to be expanded further under proposed new health and safety legislation. So Robert has mentioned enforcement action and penalties previously, but it's worth noting that breaches of safety law carry criminal liability and can lead to enforcement action, including turnover-based fines for a company if there is successful prosecution. So it's definitely important to make sure that you're compliant and keeping an eye on further requirements in this area. So in the interest of time, I'll pass back to Joanna or Robert.
Yeah, really interesting. And I've only got a couple more questions actually that are more general questions to ask, and then I'm going to stop sharing and throw it open to the floor, because I imagine we will have some questions from our audience who can either ask them themselves because we're using a different platform, or are very welcome to type them into the chat and I will ask them. But just before we get to that, I've got a couple of questions for both of you to decide who wants to answer them. The first one is, how does the Act work when somebody's workstation is at home?
Yeah, I can take this one. I'm assuming the workstation is at home in the UK, and these are workers based in the UK, and home workers are protected, and it will be in the course of employment. So I have got no doubt that will mean that that's caught by that definition. They are both protected, and your risk assessment should be dealing with your home working population of your workforce, and if you need to take steps in respect to them. And equally, they're not allowed to use their position of being a home worker in order to sexually harass anyone. So it doesn't just apply in offices or those sorts of workplaces. It is any workplace at all.
And I suppose on that, you mentioned the UK there. So do RGTs under the Act extend to company subsidiaries that are abroad?
So that's a really interesting question and quite a tricky one. The Equality Act itself has a particular geographical limit, and there are some claims that can be brought that sort of stretch or test the jurisdictional limit. So I'm not going to give a specific answer to that, but if, for example, you had a home worker working in Australia, there have been cases of them being able to bring discrimination claims in the UK where they're working as part of the UK workforce. So the geographical location, it can be a very tricky issue, and we need to look into that. I had one case where a recruitment business was recruiting doctors to go and work in just off South America, and the company there used certain discriminatory practices, but because the recruitment agency was recruiting UK doctors, the Equality Act applied in that context, and although it wasn't unlawful in the location they were going to be working, it was caught under the Act. So these are complex scenarios and something you need to take account of.
Thanks, Robert. I'm going to stop sharing now, so I can come back up on screen. So we do have a few minutes left. I can see that there are no questions in the chat. If anyone does have any questions that they want to add, please do, or you put your hand up and you can ask it directly. If there aren't any questions, it's been pretty comprehensive. Then thank you so much to our speakers. Thank you to everyone for bearing with us with all of our technical difficulties today. I hope you found that as useful and interesting as I certainly did. And for those who weren't able to join because of the time delay, you will be watching this on the thing that we've shared. So thank you very much for watching this on catch up. We'll be doing more of these types of webinars. So in your feedback, please let us know what other topics you'd like to hear about, and we'll certainly look to try and work and bring those to you. So all that remains for me to, oh, is there a question in the chat? I can see a little red thing here. Everyone saying thank you. Yes, we will share the slides. And I just want to say thanks very much to our partners at Addleshaw Goddard. It's been really interesting. Thank you very much. And we will catch up with you all soon. Thanks, guys.
Thanks very much.
Thanks very much.
Bye-bye.
Thank you.
Bye.